The cost of silencing truth. Defamation lawfare exposed. Just after 2 p.m. last Friday, the federal court delivered a monumental ruling. Judge Wendy Abraham confirmed the reports exposing gross negligence were true. The stories published by The Age and 60 Minutes were vindicated. It was a significant result, but a case that should never have gone to trial. This exposes a cottage industry, fueled by a dozen money-driven defamation lawyers. They score spectacular own goals, leaving clients facing financial ruin. Some lawyers wait like tow truck drivers at the scene of a crash. They seek out rich clients, promising a cash bonanza and reputational repair. One litigator even sends threatening letters to editors late at night. This isn't a media sob story. It's about strangling public interest journalism. Defamation laws should protect the unfairly maligned, not strangle truth. When journalism is fact-checked over years, society pays the price for its suppression. The AI freight train further imperils media bottom lines. Newsrooms face multi-million-dollar fights they cannot afford to wage. Lawyers use the threat of years of litigation to extract payouts. But their disillusioned clients are often left facing the abyss of bankruptcy. The Al Muderis case was the second major defamation action to fail in 2025. This followed war criminal Ben Robert Smith's misguided appeal and Bruce Lehrmann's disastrous loss to Network 10 in 2024. For the lawyers, the result is irrelevant. They secure their fees and move on. But their disillusioned clients are often left facing the abyss of bankruptcy. Investigative reporter Charlotte Grieve faced intense scrutiny. She endured 6 days of cross-examination by Sue Chrysantho, SC. Chrysantho, often called preeminent, questioned Grieve's very professionalism. The lawyer suggested Grieve lacked understanding of the meaning of truth. But the allegations reflected poorly on her own client, Dr. Al Muderis. The weight of evidence against the surgeon was substantial. Dr. Al Muderis had long courted the media to build his celebrity brand. His gross malpractice left a trail of pain and misery behind him. For at Charlotte Grieve and her team, the verdict was a total vindication. They successfully exposed malpractice that powerful interests desperately wanted hidden. It demonstrates that diligent journalism, even when threatened, remains essential. The challenge remains to fund the watchdog that holds the powerful to account. When Al Muderis's world crumbled, it was a fitting end to an outrageous action. The ambition of the case was outrageous given the evidence. Courts saw these actions for what they truly were, a shot in the dark. Actions driven by lawyers standing to pocket millions from desperate clients. If public interest journalism cannot hold power to account, who will? The Age and Herald showed they will always defend integrity. They stood firm against the multi-million-dollar onslaught. Other newsrooms may not afford such fights. The battle for truth demands relentless defense. Their strategy relies on legal attrition, draining resources and morale. The goal is not justice, but settlement payouts, secured by threat. They exploit tight newsroom budgets mercilessly. The high cost saps the energy of editors and journalists alike. The lawyers know the true cost of defending the public interest. They profit regardless of whether the initial claims were sound. As Michael Bachelard pointed out, the lawyers trouser their fees and move on. They collect their earnings and promptly start the next case. Their clients, however, are left with the devastating consequences. Disillusioned clients peer into the financial abyss. This cycle repeats, threatening the bedrock of free reporting. The plaintiff, Dr. Al Muderis, courted media attention extensively. He used the media to build a powerful public brand. But underneath that image lay a trail of malpractice and misery. His legal action sought to suppress the documented evidence of harm. The ambition of the lawsuit defied the weight of existing facts. 6 days of grueling cross-examination tested the reporter's resolve. at Sue Chrysanthou, SC, pressed relentlessly against Greaves' journalistic integrity. Accusations flew: unprofessional, unqualified, ignorant of truth. The irony was that those descriptions perfectly fit the opposing client. The journalists relied on meticulous, painstaking research. Months and years dedicated to fact-checking every claim published. This dedication is what ultimately prevailed in court. The lawyers walk away wealthier, having pocketed millions. The case was just one stop on their lucrative route. Their clients, however, are left with the ruins of their reputation and finances. The legal strategy was a gamble that ultimately failed spectacularly. But the journalists paid a heavy price in time and budget to prove the truth. It is positive that our courts recognize the true nature of this litigation. If public interest journalism cannot challenge power without fear, then in a free country, who will ultimately hold power to account? The courtroom buzzed with anticipation before the verdict. The evidence presented spanned years of investigation. Justice, however delayed, arrived for the integrity of the reporting.